1911, Malads, it was reversed. The partition of Bengal was reversed. But they belong to the same area. The ethnicity was different. The language was different. And all these problems were created by the British. When the independence of India took place, East Pakistan, which is now Bangladesh, was carved into a separate country. And the exodus happened because of the fact that the ethnic minorities, linguistic minorities, as well as the majority community in East Bengal, in East Pakistan was not willing to stay there. The problem on the West Coast was entirely different. On the western border was entirely different. Because on the western border, it was the Hindus who were coming into India, not the Muslims. The Muslims were given the choice to go there. That's why the date 19th of July. Not come on the 16th of August. We are people who have been displaced from Lahore. Grandparents were killed. We came here immediately on the 16th of August. But there are many people, Malads, who came here afterwards. And they had to be given refuge. So therefore the 19th of July date, therefore the mechanism. That would never have happened in Assam. From East Pakistan, there was no such, Malads. All the minorities wanted to come into India because it was originally a part of India, part of the British Empire. So when this partition took place, naturally, people of Indian ethnicity, Bengali ethnicity, their language would want to come. To try and argue a constitutional point, which is the point I'm getting at, to say that this has changed the cultural ambiance of Assam is constitutionally invalid. Because you cannot attribute this to one event. Nor is the court, Malads, has the wherewithal to do so. You shouldn't even start this exercise. More important, Malads, I have a fundamental right to move from one place of the country to another. So immigration or migration from one place to another is a fundamental right. Can some...
Within the country, of course.
It doesn't matter, Malads.
No, but within the country, this right really doesn't extend to people who are not Indians to enter in.
Malads, but they were Indian. That's the point. They were Indians. On that particular day, they were Indians. When Malads, please, in 1971, when this happened, the war happened, Malads, and Bangladesh was created. They were Indians before that.
Who's Indians?
Malads, please, Andrew, please.
No,
they were.
What's the argument?
Malads, what happened? Pakistan was created.
They were all part of undivided India.
Correct. They were correct, but they were
the government of India.
Correct. Malads, when Pakistan was created naturally, people would like to come. Malads, in 1951, people would like to come. Malads, Bengalis would like to come. Hindus would like to come. That's the point I'm making, Malads. A constitutional argument can't be made because it happened in 1951 that they came here. Therefore, Malads, it changes the cultural environment of Assam. That's not a good argument constitutionally. For the simple reason, Malads, the argument has to be applied in the context of demographic change. Demographic change can never be the basis of saying that my culture has been impacted. Can never be, as a matter of constitutional law. Because Part 3 of the Constitution in enforcement of rights, Article 21 is the preservation of rights. 29 is the preservation of rights. There's a constitutional distinction between the two. They are people of different cultures, different traditions, maybe different language. They are entitled to preserve it. Nobody has infringed that. Their argument is it has been infringed demographically. An argument that has no basis in the Constitution. They have to show violation.
Mr. Sibal, there may be some problem with this because an argument about demographic change as affecting culture can never be made within the territory of India. For instance, somebody in a particular state, take for instance, there's this huge migration which is now taking place in our IT centers. People can't say our culture is being changed because of this huge migration.
See Maharashtra, labor coming from.
Because for the purpose of citizenship law, as Attorney General has very beautifully put it in his submissions, India is one entity. Correct. So no one state or no people in one state can say that, look, by virtue of the fact that we are having an influx from other states, that our culture is being affected. Too bad. That's what the Constitution presupposes by postulating Article 19(1)d. You rightly said that, there's free movement. But this applies within the nation.
I agree. Let's kindly see 29 now.
Can the people of a state not say, suppose the union were to say that we are going to resettle, say 20,000 refugees or 25,000 refugees in a particular state. There may be substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
But I'll answer that. See 29.
You cannot have a challenge at all.
Well, that's 29. Just look at 29. Just have a look at 29. Let's read it. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. No problem. Which part of their petition says that their right to language, script, or culture has been impacted? That's not even their case. How do you bring 29 into it? The submission that I am making is this demographic change happened because of historic reasons. These historic reasons don't relate only to 1947, after 1947. These historic reasons are etched in history right from 1824. It would be difficult for the court, Bullets, to identify as a matter of fact that this happened only after 1947.
According to you, this flux was happening much before that.
Much before. It's part of history, Malad. And well, actually what happened in 1971 was the second partition of India. The sense that Pakistan was East Pakistan was obliterated from the back. Bangladesh was created, and those people, those Hindus, and
that's not a second partition.
Second partition of Pakistan. So therefore, because of that, these people came across. It's that second partition of Pakistan that resulted in part of this influx. And Parliament debated it, and I don't want to trouble your lordships. When Parliament debated it, Parliament said, we don't want to. Literature we've put in the compilation, Malad. In our compilation, I'll not trouble your lordships with it. The point I'm making is Malad, this second partition of Pakistan resulted partly in this influx. But the influx was happening, Malad, all along. But in any event, Malad, as a matter of constitutional law, they have to show as to what part of their language, what part of their script, what part of their cultural tradition is being impacted. And ultimately, what I heard the other side saying, and that's a political argument, what I heard the other side saying was, they have been even given the right to vote. 29. So, Mullahs, what happened? Now, let's come nearer home, Mullahs. Then what happened? In 1978, Mullahs, the Janata Party came to power. And, Mullahs, there was a Janata Dal chief minister. And, Mullahs, as your lordship knows, Mullahs, that government fell in 1979. Mrs. Gandhi then came to power. Now, what had been happening between 78 and 79, there were huge agitations in Assam by the student community. And if I may, Mullahs, invite you, just note it, Mullahs, there's a book called Modern Assam, which is part of the compilation, Mullahs.
Where is that book?
Yes, give the page. Kindly, just at your leisure, read chapter 12 of that book, which is titled Waves of Popular Protest. Waves of Popular Protest. Just give the page, please, the PDF. It will give you the historical context of how this whole protest started. There was price rise, there was unemployment, and then part of it was attributed to the fact that there were people who had settled there since 1951, and there were protests against that. That look, these are outsiders, so these are the others. And the agitation reached such a crescendo that it led to huge violence. I mean, the Delhi massacre in 1983 was as bad as any massacres that have happened since. In fact, the agitationers said, we would rather give our blood, but we will not give our oil. Why? Because production of oil was in Assam. And there was they stopped the production of oil. Production of oil fell. Only 3 places they produced oil: Gujarat, Bombay High, and Assam. Transportation, Mullahs, was stopped. Killings took place. Children were killed. In 1983, Mullahs, Mrs. Gandhi decided to have an election. It was opposed. 2% of the people voted in that election. And a person with 17% won the election. There was again a huge protest. I'm talking about 83. Why this 85 happened? Mrs. Gandhi was assassinated in October. The demand was that 1951 onwards, everybody who was a non-Assami who had come in should be thrown out. This was not agreed to. Mrs. Gandhi got assassinated in October 1984. Rajiv Gandhi then said, let's try and compromise this issue. In the meantime, Mullahs, Prafull Mahanta became the chief minister. And in the 2 years, 83 to 85, they got discredited. The movement, Mullahs, became weak. And the 85 Accord. Mrs. Gandhi always said, let's keep 1967 as the cutoff date. The learned solicitor rightly said, because of the 66 electoral roll. And 67, Mullahs, was the election. They did not agree at that point in time. But in 1985, when Rajiv came, Mullahs, to power, he said, no, there should be give and take. And therefore, this cutoff date was agreed to. And therefore, the 1966 to 1971 period was dealt with separately. And the other period was dealt with separately. That's the genesis. Now, Mullahs, the first submission that my learned friend gave, he gave you population figures, Mullahs. Those figures cannot possibly be relied upon one way or the other. Because you don't know the genesis of the migration. And their figures show that after 71, Mullahs, the Muslim population has been reduced. Therefore, Mullahs, yes, the rate of growth has been reduced. So the point I'm making is I'm on the first point, Mullahs. of the Article 29 point. Well, that has no constitutional basis. We're not talking about people coming from outside or coming from inside. We're saying that in any event, in terms of 29, you'll have to show infringement. And their infringement is only change of demographics. That's why they show the population figures. Change in demographics cannot be the basis of an infringement of Article 29. Cannot ever be. Unless, well, it's very interesting. In fact, if you ask me, Assam perhaps is the most multicultural, multilinguistic, the most diverse state perhaps in the country. And culture. Diverse culture. Of the 10 or 11 petitioners that my learned friend pointed out, each of them represents a separate culture. Nobody says that that's been infringed. That's not their case. A very slippery slope. Address this issue on the basis of demographic change. But this is the march of history. You can't stop this. And at that point in time, Parliament said, why should we stop it? These are our own people. Those Muslims who left India and went to Pakistan, and they wanted to return India, there was a whole different process. That's included in section 5 and 6, in Article 6. Whole different process. Because we did not want them back. Here we were welcoming them because these are people of our own ethnicity. This was an act that was recognized by the then government and allowed to happen. But they did not realize the kind of opposition that will emerge as it did in Assam. It happened in other states, but it happened in Assam.
Essentially, the Assam Accord was that 71 onwards,
Yes.
Nobody will be protected.
Correct.
51 to 66 and 66 to 71, people who came in would be protected, basically.
That's right.
51 to 66, no questions asked.
Right.
66 to 71, you got to satisfy the...
That's correct. Now, if you look at really migrations this way, for example, when the Vietnam War took place, kind of the Vietnamese people that were settled, these are all foreigners. You look at the German the Turks who have now been given citizenship, when the Germany tweaked its constitution. It's tweaked its constitution. It never allowed this to happen before. So Mexicans, there's a special provision of the Mexicans in the US. So the point that I'm making is that's the decision of the political process which allows this to happen and then makes a provision for it under the law. And there's no basis for challenging it other than the ground that it is discriminatory. But this was a non-discriminatory recognition. Not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited...
Place of residence, yes.
Sorry?
Based on place of residence.
No.
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, Mulats. I'm sorry. That is the test. That test was applied between 66 and 71. And your Lordship looks at the entry in list 1. It's entry 17 of list 1.
Yes, 17.
Which is citizenship, naturalization, and aliens.
There's no doubt that Parliament has the power. There's no doubt about it.
No, I'm not only... Sorry.
Entry 17 confers and read with 245, Article 245. Parliament undoubtedly has the power to legislate.
Correct. But they were not discriminating on the basis of residence. They were not discriminating anybody on the basis of residence. They were saying, only if you are resident will you get this through the process of naturalization. So then, under no prohibited category. Well, there's another very interesting feature as far as Assam is concerned. Assam has 5 hill areas, scheduled areas, that were created. And their autonomous councils, Mullahs. A lot of the minorities, Mullahs, never went to those scheduled areas. You can't buy land there. So they remained where they are. So the Muslim population percentage showed it had increased. So all these are very complex issues, Mullahs. How is this court going to determine all this and come to a conclusion that this is violative of 29? There's a place called Darang, Mullahs. A part of Darang was created as a tribal area. Mullahs. So the Muslim population only stayed in the other part, Mullahs, so that if you took Darang in its original state, Mullahs, the Muslim population would be less. But when the tribal area was considered, the Muslim population would be more. The point that I'm making is there are no judicial standards to determine all this. A hazardous task, judicial task, for you to come to a constitutional conclusion that because of this, their cultural rights under 29, because 29 is preservation of rights. Preservation of rights assumes that there is a violation, and because of which I have a constitutional entitlement to say, issue a writ of prohibition, issue a mandamus not to allow them to violate. That's nobody's case. It is therefore not solely attributable to migration. So that's, Mullahs, that's on the 29th. It's absolutely tenuous connection, as my learned attorney says. Absolutely tenuous connection. One has nothing to do with the other. Very, very, very. Now, let's kindly come to now the Article 14 argument. That's even more interesting. Now, I'll assume, Mullahs, that 6A is struck down. Now, if 6A is struck down, what happens? Bangladesh will not take them.
We said this will result in a group of stateless citizens.
Total stateless.
The joint communique, which was issued by Sheikh Mujibur Rahman and the then Prime Minister, clearly says that Bangladesh will take back people who had come in after 25th of March 1971.
That's correct. So, Mullahs, you cannot, as a matter of constitutional law, Mullahs, and again, if you go.
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And if you go to my submission, well, just give me power of judicial review. I've dealt with it in 2-3 minutes. I'll just finish on this aspect. Kindly come, Mullahs, to volume 2, my submissions.
Yes, we got yours. The ones, yes, we've got your volume 2.
Volume 2. At my submissions start at page 19, but scope of judicial review is at PDF 23. In fact, may I tell you, Lordship, another thing. While this agitation was taking place in Assam, many of the people, whether Bengalis or others, moved out of Assam because they were fearing that they might be killed or hurt. Many families actually migrated to other states. So, in fact, the migration to some of the other states, Mullahs, is also attributable to what the uncertainty that prevailed in the state of Assam from 1978 right till 85. And Mullahs, as your Lordship knows, Meghalaya, Mizoram and others. So therefore, the Muslims the minorities would not have gone to Mizoram, Meghalaya and other places, Mullahs. So it seemed that the population here increased in terms of percentages. So these are all very difficult aspects, Mullahs, to analyze and come to a judicial verdict. So now if you look at Mullahs PDF 23, if you just look at what Hannah Arendt said, right to have rights. That's the citizenship is the right to have rights. I've quoted the page. I won't go to it, Mullahs. Then your lordships will see laws should be interpreted, para 17. A, laws should be interpreted in a manner that avoids rendering people or groups of people stateless. The international law norm against statelessness is to be found in foundational legal instruments, both see the Universal Declaration and the International Covenant of Civil and Political Rights, and Article 20 of the American Convention on Human Rights. And Mullahs, I've given some references there. Your lordships may have a look at it. And the idea is that courts should attempt to harmonize domestic law with international law. That's Visakha Mullahs has set that out. And lean towards upholding laws in cases where striking down would result in statelessness. And then citizenship laws should not discriminate on prohibited grounds. As citizenship is the right to have rights, and deprivation of citizenship renders individuals particularly marginalized or vulnerable. For reasons advanced above, courts should subject facially discriminated citizen laws to strict scrutiny. Is to protect individuals. So, Mullahs, this takes, and then Mullahs, somebody else in West Bengal or another state can say, you give me the same rights, but they cannot say, now you declare this as illegal, and therefore, where will they go? And Mullahs, the commitment to fence Bangladesh was made in 1985 itself. So 15 years and 23 years, 38 years have passed. The fencing has not happened. Should have happened. And this creates more problems for India, as your lordship said, because after 1971, what will happen? Children would have been born here. Can your lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Will they go? So that's, I don't want to enter into that. It's another area altogether. So that takes care.
Equally, there is substance in this grievance that, on the one hand, we don't have an open border.
Yes.
We do not say that anybody from Bangladesh can come and settle down wherever they want to in India. At the same time, if we don't take action to curb illegal migration, then it causes all these problems in India. The feeling in India that, look, the infrastructure is limited.
Absolutely.
Education is limited.
Absolutely.
Public hospitals are limited. We can't allow for an unlimited influx.
Absolutely. No, you're right. And this is the problem. Therefore,
we passed that order, which we did this afternoon. What are you doing today?
It's the executive that is to blame, Mullahs. There's no doubt about it. And right from 85. I think we create problems for ourselves. And then what happens is, Mullahs, it becomes the other versus us. This is the heart of the problem. It is no longer a cultural issue. It's a political issue. Others versus us. Who gets power? Why do you give them electoral rights? This is the problem. Don't give them the right to vote. So therefore, you, in the process, are creating divisions in society, whereas your preamble talks about fraternity. Now, what is fraternity, Mullahs? Live and let live is Article 21. Be and let be is secularism. That's what it is. And that's fraternity. And the entire argument on the other side is countering the concept of fraternity in the preamble.
So, Sibyl, how do you, I mean, this is not a question in the sense to tell you that you're wrong on this point, but just a little assistance. How do we sort of conceptualize subsection 2 of section 6A and subsection 3?
All right.
Subsection 2 deals with people who are in the electoral roll as on 1/1/1966.
Right.
They're all post-1951 people,
right,
but who are in the electoral roll as of 1/1/66. Right. That's why subsection 2 refers to the electoral roll of 1/1/66, 66 electoral roll.
Right.
The subsection 3 covers people who are not in the electoral roll of 1966.
Correct.
They came in later until 71.
Correct.
So what was the reason for protecting those whom they protected first in subsection 2? Was it that Parliament wanted to protect people who are Now they've come on the electoral roll as on 1166. So we say, all right, you have now been assimilated. We have already, whether you are legal, illegal, we sort of make a blanket conferment of citizenship. What was why these two bifurcations into subsection 2 and subsection?
I will try and answer that, Malad. There are two reasons for it. Number one, even those whose names were in the electoral roll, people objected to them. People objected to them, saying they got themselves into the electoral roll. They did not come here prior to 1966. That's why the whole NRC exercise has taken place. And at the end of the NRC exercise, do you know what the result is? Your Lordship asked that question, they should have told you the answer. The answer is, today there are 19.06 lakh people who are left out of the, and whose appeals are pending. That's all. And the majority of them are Hindus. So it's not as if nothing happened after 71. This exercise has been done and done in 8 years, Mulaj. Mulaj, that's why Justice Gogoi said, everybody will have to produce the legacy tree, legacy data. Who was your great-grandfather? Even those whose names were on the electoral roll. So in the NRC, every citizen, every person in Assam had to face the test. So in fact, from a statutory standpoint, what my lord is saying is right. From the actual standpoint, it's just the other way around. Because there were thousands of objections. Well, somebody didn't have a school certificate. Well, who gave a school certificate at that point in time? Then you had to show, no, my great-grandfather lived in that village. Then there had to be a linkage document. Then you had to produce somebody from a nearby village or the village in which you lived, and he came and made a statement, no, his grandfather was living there. So, Malaj, it may be as a matter of law for you to say that's not factually correct. Well, the whole NRC exercise was that all this may be wrong. It was monitored by this court. And it ultimately found that the majority of the 19 lakhs were Hindus. 1,600 crores was spent in that exercise. So the point that I'm making is, Malaj, while your lordships asked me that question, the factual situation is in fact just the opposite. Because I don't want to bring any politics into it, because everybody objected to a particular, that he doesn't belong here. Of course, that exercise is still going on. But Malaj, therefore, it would be dangerous, and this is my respectful submission, to move into areas where it's difficult to come to a judicial determination. That's why 6A was a matter of policy. It was legislative policy pursuant to a political accord which sought to maintain a status quo subject to processes. Those who came between 66 and 71. Yes. And if they do not formulate how 29 has been violated, why would your lordships go into it? But that's really the answer to your lordship's question. That everybody was questioned. It just so happened that once you're on the electoral roll, then you have a leg to stand on. But that was not the end of the story. It's not as if everybody who was on the electoral roll was accepted as a citizen. And then, Malaj, the argument that they owed allegiance to Pakistan, I don't understand that argument at all, Malaj. When I am born, Malaj, do I have an oath of allegiance to give? Or if somebody is granted citizenship? Well, people don't give the oath of allegiance. When people came from what?
See, the upheaval, actually, as a matter of history, when did the upheaval start taking place in East Pakistan?
Upheaval started taking place in East?
No. The 66, I'm talking about the leading up to Bangladesh.
Lordship knows, after the Bhutto election in particular, but the fact of the matter is that those belonged to an entirely different cultural tradition. This was all part of Bengal, Malaj. This is East Bengal and West Bengal.
China went to will learn. That's when it started.
So all this is the oppressive policies of Western Pakistan, so to say, or now Pakistan, right? And what is happening there to the Hindus today was thought to be done to the Bengalis. It's as simple as that. Who would want to stay there? The impact of it, because they came this side, the impact of it was what happened in Assam later. It's bound to limit resources. They were claiming that their education should be free. And then what happened? The tea plant, see, the tea planters came here much before 1951.
Operation Searchlight
Yes.
is initiated by General Yahya Khan on the 25th of March.
Yes.
Now, interestingly, Section 6A, 25th of March 1971, is not the commencement of the provision. It's the end of the provision.
End of the provision. Yes,
right?
Yes.
So, if at all, one would anticipate that the influx would take place around or after 25th of March 1971.
It didn't.
What the statute does is to go back 5 years to 66, 1166.
Yes.
What is the reason for that 1166?
As I told you, but 66 because of the electoral roll. After that,
The electoral roll of 1166,
yes,
which was used for conducting the elections of 67,
yes,
covered all those people who had entered India prior to 1166.
yes,
Right?
yes,
That is covered by 6A2.
yes.
Just see how it is. Just tell you how 6A is worded. 6A2. All persons of Indian origin who came before the 1st of January 66 to Assam from the specified territory,
Right.
now bracket, very important, including such of those whose names were included in the electoral rolls for the purpose of the general election to the House of the People held in 1967.
Correct.
That is to say, the 1967 election was held on the basis of the electoral roll of 1166.
Correct.
Yes.
That covered people who had come in prior to 1166.
Not necessarily, people may have come prior, but they may not be in the electoral roll.
You're right. I'm not talking the exclusion.
Yes.
But 6A2
Yes.
covers people post 1166.
Yes. Yes.
Right? I can understand 6A2. 6A2 says, whoever now we have included in our electoral roll, we'll give them citizenship. Therefore, anybody whose name was in the electoral roll of 1166 got the benefit of citizenship, but under which provision? Under 6A2.
Yes.
Now, what is the logic for 6A3?
But I'm saying, many people who had come in even earlier, but they had no evidence to show. Kindly, there are many people who came in earlier. No. The war is later. War is not then. It's 65 war happened.
6A2 you cannot justify on the ground of the Bangladesh liberation.
No, I'm not. There is a Pakistan war, Indo-Pak war of 65.
1965, there was a war. There is the Indira Gandhi Pact. Jeep and Indira Gandhi agreed. Right? Those
election took place in East Pakistan. Mujibur Rahman won. There was it was unleashing of violence. He was not allowed to be sworn in. That's what happened.
70.
Yes, in 70, December 70. That's the violence that happened. He was not allowed to be sworn in.
But that is 3 months before our cutoff.
That's why, Malad, that's precisely why I'm saying, Malad, that 3 months has been also excluded, as your Lordship sees now, from March onwards. Therefore, Malad, it has nothing to do. This exodus didn't happen from East Pakistan or Bangladesh at that point in time. This is all prior.
I mean, there's one way of dealing with it, which is that Parliament has legislative domain over what cutoff date to adopt.
That, of course.
Unless the cutoff date is palpably arbitrary.
That's correct. That's correct.
You normally allow Parliament.
But apart from that, Malad,
I mean, that can always be a judicial mantra, but we are trying to figure out what is the logic.
But Malad, it's not just a cutoff date. It is to prove, if you prove your residence.
Sorry?
It's not. All right. Said Malas, a person who got 17% of the 2% vote, Malas won the election. So that was rejected by the people. So it was, but Malas, the 66 onwards, you had to show evidence that you were resident for 10 years.
Let Mr. Zibal,
so therefore, that's over.
Anything else?
No, I don't think so. I just want to. No, one second. I don't want to waste the court's time. Anything else? Therefore, there are only two aspects, the date and the territory. No, I don't think so. The tea plantations, the traders came much earlier. So the date and the territory are the two aspects, which are considered and deeply obliged.
Thank you, Mr. Zibal. Yes, Ms. Jaising.
Huh? No, my lord is only confining to 6A. Why are you worried? They were worried they'll go beyond 6A. Of course not. We haven't argued that.
No, we are very clear in our mind. We have not heard
Mr.
Diwan has not argued that. Mr. Solicitor has not argued anything beyond 6A.
Because 2024 is round the corner, then nothing should be.
I don't think that is.
No, I'm saying
2024 has no relationship with the constitutional being.
No, I'm saying nothing should be said.
But Mr. Sibal, equally, we must make it clear. You probably all have, you've got the drift of it, irrespective of what happens to 6A, and our minds are open until the last word is said by Mr. Diwan and the others. Irrespective of that, we intend, because it's a constitutional court, on what is being done to take care of the problem of illegal migration. That's something which I think we have to address in this judgment. And we do propose to address it, because irrespective of what happens to their plea on 6A, I mean, the cause of the petition, there is a great deal of there's a great deal of substance in what their grievance. I mean, look, what are you doing to our state?
Therefore, I will not very categorically and candidly say that I am not trivializing the problem.
No, neither are we.
I am answering only the constitutional question. This is a serious question, and as a custodian of fundamental rights of all citizens, the Lordship
we have to address that in any case.
We must, all of us must. No doubt about it.
Yes, Ms. Yes, Ms. Jaising.
May it please, my lords. My lord, I would like to take off from where Mr. Sibal left off. I think the question of plenary powers has been adequately addressed. I will not address that, except to say,
Request Mr. Sibal and Ms. Jaising to just indicate who they are appearing for.
yes,
that we
I
have a
that I want
Yes,
to
Mr.
we have a
precisely
sense-
that.
But I didn't ask you your repetition.
Yes, my lord, I'll give you my
It's
repetition.
my notes, my lord, who I'm appearing for.
My lord, let me give you my repetition numbers. It's the very first one on board, 274 of 2009, which was originally titled Assam Public Works, now called INRI Section 6A. I'm appearing as an impleaded respondent in the first writ petition.
We do what we have done in the 370.
It's now called INRI 6A.
Apropos what fell from Ms. Jaising a moment ago, as we have done in the case of the marriage equality, Article
Yes.
370, can we call the judgment in Re 6A of
My
the
lord,
Citizenship
I would
Act?
agree with
Yes,
that,
yes.
respectfully agree.
Mr. Diwan, I think
Yes,
that's already there. That's already there.
yes, it's already showing on the board as INRI 6A. It's showing on the board as INRI 6A.
So what is the
But my
subject?
lord, since the question has been asked who I'm appearing for, I'm appearing for an impleaded respondent in writ petition number 274 of 2009, which is the first item 501 on board today.
You are applying for the impleaded respondent.
Impleaded respondent in All Assam Minority Students Union is the name of the respondent. I am also appearing, my lord, for an impleaded respondent in writ petition number 562 of 2012. This is the petition in which the order of reference has been made to this court.
Writ
It's the
petition number,
reference.
writ petition number.
562 of 2012.
There again, you are appearing for one
For
of the
an
respondents.
impleaded respondent, impleaded by an order dated 23/8/2013. And the latter, my lord, is the one in which the reference has been made. Now, my lord, as I said, let me begin with where Mr. Sibal has left off. My lord, it has been said by academics the world over that the 21st century is the century of refugees and migrants. And if you shifted one century back, then the 19th century also was a century of refugees and migrants insofar as India is concerned. My first submission is that the Constitution of India bears the birthmarks of partition. And you cannot understand either the Constitution of India or the Citizenship Act without understanding what happened for almost a century before the partition occurred. And what led up to this partition. And the birthmarks are there in the Constitution. Article 5 confines itself to the commencement, as has already been said. 6 and 7 deal with migration to and from Pakistan. And the Citizenship Act deals with acquisition of citizenship after the Constitution comes into force. My submission is going to be Section 6A is a sui generis provision. And that's why it's called special provision. So it cannot be slotted either into the Constitution or into Section 4 and 5. Possibly it can be slotted into Section 7 of Article 7, a proviso. Because my submission is the proviso to Article 7 leaves the door open for further migration and does not freeze the cutoff date at 19th March 1947. 1948. There's no freeze to migration, or there's no freeze to granting citizenship to people who enter India after 17th March 1948. And that is obvious from a reading of the proviso to Article 7. I'll make good that submission. Then, my lord, I'll address a few issues on Article 29, because 14 has been adequately addressed, 11 has been adequately addressed. I will not cover the same ground. My lord, in my opinion, 29 has not been adequately addressed, and I'll attempt to do so. In fact, the Attorney General did not address 29 at all. I'm sorry, the Solicitor General made no submissions on Article 29. And my lord, from what I understood by the opening arguments of Mr. Diwan, his major focus was on 29. And that major focus was confined to demographic changes. Nothing more, nothing less. It was not his case that the script, the language, or the culture of Assam has been impacted. If it was, I have not understood in what manner. And may I explain, my lord, I would like to invite your attention to certain provisions of the Constitution of India. Assamese continues to be in the schedule of official languages of India. Point number one.
1 second.
Under the Constitution, adequately, completely protected. No question, my lord, of destruction of the language. Number two, Assamese continues to be the official language of the state of Assam. Remember, my lord, at one time, Mr. Sibal informed you that Bengali was forcibly made the language of Assam. That was reversed. And Assamese continues to be the official language of the state of Assam. Therefore, my lord, there's complete protection of language script.
Assamese is not the official language of the state. Bengali is also the official
Yes.
language of the state.
Yes.
And Moro is also an official language.
Yes, my lord, I'm grateful for that information.
Assamese is the only.
My lord, I'm very grateful for that information because we are talking about a state which is bilingual. And therefore, my lord, what is the point of producing data to show the number of Assamese speaking people as against the number of Bengali speaking people in the state of Assam? It makes no sense. It's a bilingual state, a multilingual state. And as Mr. Sibal submitted, my lord, it is one of the most diverse states in the country because of the mass migrations that have taken place over the centuries, my lord, long before the Ahoms came to India, long before that. There has been migration into Assam. And this has led to the creation of a syncretic culture. More submissions were advanced on how the culture of Assam has been impacted. Now, my lord, a few more provisions of the Constitution of India need to be pointed out to see the special protection given to the state of Assam. First of all, under Article 342, the president of the parliament passes laws naming scheduled castes and scheduled tribes in different states. And my lord, I will share it with you because it's in the public domain. There is a law of parliament in 1976 which gives you the names of the tribes who have been put in the presidential schedule. The intention being to protect their culture. These are constitutional provisions for protection of culture which are in place. And my lord, your lordship will turn to Article 244 of the Constitution of India. Going through the list of constitutional provisions which are intended to protect the state of Assam and in particular the tribals. My learned friend Mr. Diwan said each of his petitioners represent a certain tribe. And I presume it was his case that it was tribal culture which is being destroyed. Now, my lord, we turn to 244 of the Constitution. Yes. Administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. Special provisions have been made for these states given their history. Now, my lord, the provisions of the 6th schedule shall apply to the administration of the tribal areas of the states of Assam, Meghalaya, Tripura, and Mizoram. Then come to Article 244A, formation of autonomous states comprising certain tribal areas in Assam and creation of local legislative and council of ministers of both thereof. There again, my lord, there's a special dispensation for self-governance of tribal areas. One of the submissions made was self-governance is covered by Article 21. No attempt was made to justify that submission, but I'm giving you the answer. If self-governance is a right, yes, it is protected insofar as Assam is concerned in relation to tribals under Article 244A. Tribal areas have been put in a separate schedule which gives them autonomy of administration. Now, my lord, these are the provisions which conserve customs. And if custom and culture are synonymous with each other, then their culture is protected. Please don't understand me to say custom and culture are synonymous. They are not. But nevertheless, assuming for a moment that culture and custom are synonymous, my lord, they are adequately protected by the Constitution of India, and no case has been made out for violation of rights under 29, which was the major argument addressed by the opening argument. Now, my lord, this being said, please turn to Article 247. Sorry, it's not 247, it's 27.
Actually,
Yes,
he
you
is
have.
guessing.
Yes, he has.
Read at page
But read those
49 or
articles.
page 49 of the.
Yes,
solicitor
Lord, there is a list.
There is
There
para
is a list,
133.
but I would like you to see the provisions of those articles, 275. 275. Well, Lord, your lordship talked about development. Here is the answer to
It's
development.
already there. It's grants from the union to certain states.
Mandatory grants for Assam, my lord, not for the rest of the country.
Yes.
Please have a look. It is for what? For development. Mandatory. Whereas the others are at the discretion of the Union of India. When it comes to Assam, the word is shall, provided that there shall be paid out of the Consolidated Fund of India a grant in aid of revenue for the state of Assam, sums capital and recurring equivalent to ABCDE. Therefore, my lord, the brief submission that I'm making is that the Constitution adequately protects the right to culture of the residents of Assam. Now, my lord, I want to move to another issue. My learned friend used the expression throughout his arguments, indigenous people. Please note that the Constitution of India does not use the word indigenous anywhere. It uses tribes. I, for one, my lord, do not know who is an indigenous person of Assam. I don't know, because there is no legal definition of indigenous person in the Constitution of India. There is a definition of scheduled castes, scheduled tribes, and my lord, the rest of us who are citizens of India. So, my lord, kindly be a bit cautious about the use of the word indigenous. Instead, we can use the word tribes. The question then will be, is the culture of tribes endangered in any manner? And if so, by whom? Now, my lord, let's see the plain wording of Article 29. Just the straightforward reading. And my lord, it certainly surprised me. I don't know whether this court will be surprised. But in the last 75 years of the functioning of this court, I have been unable to find a judgment which defines what is culture. I was looking very hard, my lord, to see if I could find a judgment which I could present to you, which would precisely give you the content of the meaning of the word culture, so that it would enable us to decide when is it undermined. But there is none, to the best of my knowledge. Not my research could be limited, but this is my submission before you. Now let's read Article 29 and see what we can make out of it on our own. Without reference to any guidance from precedents. Protection of the interests of minorities. Well, not interestingly, the title of 29 differs from its content. Although it refers to interests of minorities in its title, in its content, it refers to all citizens, any section of persons. So the right to culture can be conserved by minority and majority citizens. So if you read it, any section of the citizens residing in the territory of India, it doesn't say any minority citizens. Any section of the citizens residing in the territory of India or any part thereof, having distinct language, script, culture of its own, shall have the right to conserve the same. The next one, my lord, we are not concerned. It's about preserving educational institutions. It's nobody's case that any educational institution has been destroyed. So now, my lord, I would ask myself the question, how does one understand the word culture in Article 29? As I said, finding no guidance from the court, I tried to present something in my written submissions, culling out information from several authors around the world. And what we found, my lord, is that it is an expression which is notoriously vague. So if your lordship turns to volume 2, page 74, under the heading Submissions to the Challenge Based on Culture. We submitted that Indian culture, including Assamese culture, is syncretic in nature. For want of a better word, I use the word syncretic. Freedom of movement and residence and settlement throughout the territory of India effectuate and comprise part of India's syncretic culture and unity. But Lord, why do we have this freedom of movement across the country? In order to preserve our syncretic culture. We are allowed to go anywhere, do anything, and all our fundamental rights. Tomorrow I can migrate, but I don't know. Indian law does not recognize citizenship of a state. Let's be clear about that. Citizens of India. My lord, in answer to the question, why is ordinary residence so important in our citizenship laws? Wait, I'll be reading this further. I want to point to one thing. If you see Article 5 of the Constitution of India, it uses the word domicile. At the commencement of the Constitution, every person who has his domicile in the territory of India. The significance of ordinary residence, permanent intention to permanently settle. My lord, even domicile is not a very well-defined concept. But taken from private international law, we know that domicile means the place where you reside with the intention of making it your home. That's the definition of domicile. And my lord, domicile, in fact, in this country has caused a lot of problems given the federal nature of the country. When it comes to things like admission to medical colleges, my lord, and states make reservations for people who are domiciled in their states, all those disputes have landed up in court. Whether any such preference can be given to domicile, and it remains, I think, an unresolved issue. But the reason I'm pointing to domicile is there are two running threads in the Constitution Part 2 and the Citizenship Act. One is the concept of permanent residence and intention to settle. And the other is persons of Indian origin. And here I would say Indian origin necessarily has to refer to undivided India, because Article 6 and 7 give them citizenship. So there's a running thread in the Constitution to give citizenship to persons of Indian origin. In fact, my lord, the demand, as your lordship knows now, is that NRIs and overseas citizens should be given citizenship, and the late Mr. L.N. Singh, we had agreed to this, after which we got the concept of long-term visas and overseas citizens, where the government now issues those cards. And currently, my lord, there are petitions pending before you, which talk about why we should not be allowed to have dual citizenship of different countries. Now, of course, I don't want to get into that issue. But what I want to emphasize, my lord, is that these are the two running threads. So 3 running threads. 1, the birthmark of partition. 2, the concept of giving citizenship to those who make their domicile in India, and 3 persons of Indian origin. Now, my lord, Article 6A satisfies all these 3 conditionalities. In principle, procedure, etc., is a different issue. But all these 3 conditionalities are satisfied by Article 6A,
These are the 3 conditionalities.
as Section 6A of the Citizenship Act, my lord, and therefore its constitutionality must be viewed in that context.
Which are the 3 conditionalities?
One is the relevance of the birthmark of partition in this country. Second is the intention to reside permanently in India. And the third is a person of Indian origin, India being defined as undivided. These are the 3 guiding principles for determining the constitutional validity of 6A. Has Parliament gone beyond these principles?
What
It
is
has
the
not.
second one, madam?
The second one, my lord, the second one is the intention to reside permanently or settle or resettle within the territory of India.
What is the third, brother? Third kya tha?
Person of Indian origin.
Yes, person.
So, my lord, when it comes to culture, I'll just conclude by saying, I'll just take you back to my written submissions to show you how notoriously vague the concept is. Now,
Actually, you know, if you really look at that, culture is such an amorphous concept. Culture is you can say in so many ways, a product. I was just identifying, you know, what goes into culture. You say Indian culture. Is there an Indian culture? And then, so all of us believe there is an Indian culture because we belong to this syncretic culture of the nation. But what is it? What goes into it? You can say language.
yes,
Not that your language is culture, but our relationship to our language is an equally a part of
defining
culture. You
part
have
of
your
identity,
you have your
my-
aphorisms, you have your colloquialisms. They go into sort of making up your culture.
yes.
Art, belief.
Language,
Yes.
customs. See, I've identified a few things: language, customs, social institutions,
Yes, my lord. But-
religion, your religion,
Yes, yes, my lord,
Uh,
all of that.
practices,
Yes, my lord, all of
Food.
that. So,
food,
food,
apparel,
yes,
geographical conditions,
yes.
relationship with nature.
Yeah.
For instance, you go up to Ladakh, you go to Zanskar, you'll realize that, you know, the culture is a product of your relationship with nature when you travel to those areas. Or you go down to, say, the west coast of Maharashtra, you'll see so much of use of coconut. Why? Because of the fact that coconuts grow there. You go down to Kerala. So even that's all, it all goes into into the generation of a cultural tradition. So culture is not specific to any of these items, but is a unique, is an interplay of all this that produces a culture. Music has a very important bearing on the production of culture.
Respect to law and order.
It's a way of living.
Respect towards law. That's why in certain parts you see people are more into millets.
Well, Lord, with respect, I agree. All these elements make up culture, and it's an aspect of our identity. But, my lord, your lordship will also bear in mind that we self-identify with a particular culture. It's a self-identity with a particular culture. Nobody's forcing it on us. And, my lord, we cannot forget that this country was reorganized on linguistic lines by the States Reorganization Act. At the end of the day, my lord, the entire country was reorganized on linguistic lines because language is an important element of identity of a human being. This is the reason why it was reorganized on linguistic lines. So, and this is why language is protected, especially under Article 29, under the right to culture. You know, there have been so many language disputes in this country. Your lordship knows whether the 3-language formula should be adopted, whether Hindi should be enforced on non-Hindi speaking states. The disputes are endless, but it's because there is so much identity with language. An individual identifies to such an extent with language that it's a separately protected right under the Constitution. So, my lord, I've gone on to explain that it's notoriously amorphous and it's a notoriously overbroad concept. And I have finally come to the conclusion, my lord, that judicially, your lordship can only accept constitutional culture, constitutional morality as the culture of every citizen of India, in addition to any other culture that they may have. Why has this court taken such pains to emphasize the issue of constitutional morality in this country? Because we are a secular country, my lord, and because every section of the citizens have their rights separately guaranteed. And my lord, insofar as religion is concerned, my lord raised religion as part of culture. It is separately protected under Article 25.
But everything that of this is separately protected.
Yes.
Your right to food is protected by 14. Language is protected independently.
Yes.
But culture is what emerges from this, the interplay between all these. It's
Yes.
a way of living, as Brother Sundaresh
But
said.
it's self-identity with the culture. Nobody can tell me you identify with somebody else's culture. We create our own cultural communities and we identify with them.
And there are subcultures as well. We all say that we have a culture as Indians, but we then also have culture. We have also a culture as belonging to the state where you come from,
Yes,
the area
my
of the state where you come from.
So, my lord, that my conclusion, and I won't bother you with it, is that when this court is venturing to answer the question, if at all, what is culture, my lord, kindly bear in mind that we already have a constitutional culture in this country, built up through precedents of this court and through the very document that we are reading today. And I would say that it is that constitutional culture
I don't know.
which cannot be endangered.
Thank you, Ms. Jason. Thank you
Yes,
so much.
my lord, one more, there are some questions that I need to answer. In the list of dates I've given, my lord, in fact, a very famous senior counsel of this court has migrated to India. In his autobiography, he records that he migrated from Burma to this country. So who is Indian, who is not? Who is Assamese? There is no definition of Assamese at all. We are only resident.
Walk from Burma to India. Assam.
And Assam was part of Burma, actually, and then ceded to India under a treaty with the Burmese. So, my lord, as Mr. Sybil had indicated, the cross-migration that has taken place in Assam includes Hindu, Muslim, Christian. A lot of the tribals are Christian, my lord, in the state of Assam. Those who have gone into the autonomous areas. Therefore, my lord, to present demography, my point is only this. I'll just read out one small paragraph. That to offer demographic data as evidence of impacting culture is not constitutionally acceptable. I'll read it out I'll just give you the 3 reasons why. Because, my lord, the statistics don't tell you what were the causes of this demographic change. Now, my lord, what could be the causes of demographic change? I'll spell them out to the best of my knowledge. It could be, my lord, at the basic level, the argument expresses on the moves on the assumption that demographic profile has changed primarily on account of cross-border illegal migration. That's the argument. While an increase or decrease in demography may be on account of various factors like fertility rates, interstate migration, illegal migration, etc. The petitioners have not been able to demonstrate through any reliable data as to the cause of the alleged demographic change and the quantum of demographic change due to immigration. The only data that has been provided is the increased proportion of Muslims as compared to the average rate of growth of population in the state of Assam. But the data shows that the growth rate of Muslims is lesser than that of scheduled castes and scheduled tribes in those states. Also, growth rate of Muslims in Assam is lesser than in MP, Maharashtra, Haryana. That's merely because of average growth rate of the state does not last point. Yeah, yeah. There's just one other issue, if I may seek your indulgence, which I need to address. References have been made to the fact that immigration is external aggression. This is, to say the least, my lord, an argument of alarm. Migration, my lord, could be on account of distress.
Sarbanan Sonowal said,
I am arguing, my lord, that that judgment requires to be overruled. Do it or don't do it, that's your option. But one minute, yes, if it's not an issue, fine. But I just want to put it on the, my lord, please, now please. Now, please, it's in the very order of reference. No, my lord, Sonowal says that. Now, what are my reasons for not saying it, my lord? Article 352 of the Constitution of India, which talks about declaration of an emergency, uses the expression war, external aggression, or armed rebellion. Therefore, my lord, the word external aggression must be read eugistum generis with war.
but suppose a cyber attack is launched on one of our states. Government of India can say we are duty bound under Article 355
Of
to
course,
protect.
Lord, I don't deny that.
So external aggression today is a very broad, it could be a cyber attack, for instance. It doesn't have
But
to be-
internal, I'm not, to 1 minute, I'm not talking about internal disturbance. Internal disturbance, obviously the union has a duty to protect every state from internal disturbance. I'm saying, can you refer to migration as external aggression? My answer is no. Now, 1 minute, my lord, in that very judgment, the criteria of whether it is external aggression or not is dependent on what is the animus belligerent. What is the animus of the person who is being aggressive is the touchstone to decide whether it's external aggression or not. If it's a belligerent intent, it is external aggression. Now, migration that has taken place, especially from the subcontinent, the undivided subcontinent, is a distress migration. It's a migration which has taken place, my lord, with the intention of finding safe harbor in India. You may not want them. In your sovereign right, you may want to get rid of them. But to describe them as external, as
We got your
aggressive,
point. We got your point. What you're saying is that people who have migrated have at the least come in search of a safe harbor, or they are fleeing external conditions of atrocities or violence. And therefore the attempt is not to destroy the Indian social fabric, but to protect their own way of living.
that is the touchstone for deciding whether it's external. And yeah, no, excuse me, it is in a black and white judgment of this court. And that's why it's my duty to address it, my lord. And my learned friend read it out specifically. These are arguments of alarm. And my lord, it is my respectful request to you to revisit that passage. In that very judgment, you'll find the touchstone of animus belligerence as the touchstone for deciding whether it is. And my lord, reference has been judgment of 1883 of the United States Supreme Court, where Chinese immigrants were turned back. Now, my lord, those statutes of the Supreme of United States have been repealed, precisely because you cannot look at an immigrant as an aggressor. And finally, my lord, the judgments of the Supreme Court which have been relied on in that judgment were overturned in Trump versus Hawaii in 2018. Therefore, my lord, there is a case made out by me for you to revisit that passage. I don't say don't address the question of illegal immigration. That's not my case, my lord. All I'm saying is they cannot be described as aggressors, as it cannot be, the migration cannot be described as a form of external aggression. There may be so many remedies. And last but not to answer the question raised by Justice Sundaresan, in the list of dates, there is an extant statute which was enacted in 1950, which talks about expelling people from Assam. Even that statute, it's at entry number 1950. It's known as the Immigrants Expulsion from Assam Act 1950. And it gives to the union the power to expel. an immigrant from Assam. But my learned friend has also pointed it out.
No, it
It
is
makes
repeal.
an exception.
That's repeal.
If it's repealed, then I stand
repeal.
corrected. I
Yes,
stand
it's
corrected.
repeal.
All right, I won't refer to it. But at the relevant time, my lord, it exempted people who came due to civil disturbance. That question was asked, how do you describe these people? That's why I'm addressing it.
Now, we are almost concluded on this side, almost, I said. Who else? Mr. Hegde is there, Malika is there, then.
So I'll just take 3-4 minutes. I agree with the Aswan Gun Parishad. I'm supporting the Lord Solicitor General. Just 3-4 minutes.
My lord, just one note of
Point which are not.
Can we now just,
Very good.
can we suggest one thing?
Well, not-
Just one thing, Ms. Jason. Can we just suggest this? Let's get the order clear. Sanjay, Sanjay, just take it down. We'll first hear Mr. Sanjay Hegde.
Well, the written
Then
submissions
Mr.
are filed in
then
sequence.
Mr.
They are in volume 2.
But you tell us, we just put it down here. So,
Yeah, let's-
see, everybody knows who's first and who's next. Then,
I would have finished today itself. Yes, I won't take very long.
all right, then Mr. Sanjay Hegde, Mr. Anupam Lal Das, Mr. Mr. Yeah. Then Mr. Siv Singh,
So myself also, Dr. Will.
and then, then
I
myself.
will ask, Lords, I'll take only 5 minutes because I have comprehensive written submissions. I'll just point the headings so that Lords in 5 minutes.
All of you are now going to follow, have filed the written submissions?
Yes.
Can we just suggest one thing? Can we just suggest one thing? Who's the nodal council?
Mr. Ayubi.
Ayubi.
And the
Shara is also here.
Rai.
So what we'll do is, everyone, please put down your, whatever you want to say in not more than 1 page, bullet points. Give it to Diksha.
Yes.
So we will, Diksha, you put it in the order in which we have now mentioned. We will look at that 1 page bullet points to just take us through that in rapid fire so that we'll finish in about, at the outer limit, say half an hour. So, 11 o'clock, we will hand it over to Mr. Diwan, Mr. Chaudhary and Mr. Hansaria to make the rejoinder. We'll wrap up by lunch. So, but do make sure that all of you have that 1 page bullet point so that we know while dictating the judgment becomes very complex otherwise. We know then what exactly has been stressed by those who followed from the main council.
President Roosevelt used to say, if it's important enough, only one clause.
Oh, give me my, this thing calls list.
Have your lordship's permission, my lords, just wanted to know the lordship's pleasure regarding that Asia resurfacing, my lord, is it to follow or not?
Mr. Dwivedi, we are
Yes,
definitely taking HR resurfacing because it's a matter which is causing, there's quite some concern in our district judiciaries because
So tomorrow your lordship will take it
follow
up?
the order of the High Court or the fact that
Yes,
there's an order of
that's
the
right.
Supreme Court.
That's right, my lord.
Because
You lordship will take it up tomorrow, my lord?
all stays will be deemed to be vacated after
Yes.
6 months. So
74.
what we will do is, that's a
Yes.
different combination because I think Justice Oak and Justice Mithila join. So
Yes, ma'am.
perhaps if we finish this on Tuesday by lunch, or ideally let's begin after this gets over, instead of keeping it say Tuesday after lunch, suppose this spills over by 15 minutes, we can then keep it on Wednesday morning. I think that's much better. I don't think the whole matter should take more than an hour between you and
I
the.
appear for the state of UP. It can't take more than half an hour.
Mr. Dwivedi, how long will you take?
Lord, half an hour, my lord.
All right. So Wednesday morning we'll keep it.
It can be taken also on Friday, my lord, if your lordship so finds convenient.
Friday will be miscellaneous,
Yes.
Let's do it on Wednesday so that, that
Yes.
1 hour we'll be there.
Yes, Your Lordship. All right.
And a
I
short
just
note
want to
maybe
point
on
out
the
that
website.
writ petition 274 is before a
Mr.
different
Dwivedi's
bench.
submissions have come. Mr. Solicitor, if you are giving something.
I shall file it by Monday, my lord.
Well, look, this first writ petition is actually being monitored by a different bench. So I just want to say that the judgment in this case, we hope will be confined only to constitutional validity because it covers a wide range of issues beyond constitutional validity. This writ petition 274. So the judgment will not
6A,
dispose of
6
274.
6A and whatever we have passed an order, short order, where we want a disclosure by the Home Secretary.
Right.
I request everybody to take their seats, please. Kindly take your seats. Yes, Lordship.
यार मेरे को क्या दिखा रहा है टॉप में टीम को सॉर्ट आउट नन्ना को
We request everyone to take their seats, please. We are about to start with the session 1 for the day. Good afternoon. Welcome back, everyone. Let us start with the first session of the day. It is about the 100 years of Dr. Ambedkar's enrollment as advocate. We will also reflect on his ideas of constitutionalism. The golden words of Dr. B.R. Ambedkar resonate even today. As he said, ours is a battle, not for wealth. Ours is a battle for freedom, for reclamation of human personality. Baba Sahib's thoughts, as reflected in his writings and speeches, have significant importance in tracing the history and growth of social thought in India. May I request Honorable the Chief Justice of India and Honorable Minister of State Law and Justice to release the web page on Dr. B.R. Ambedkar, the architect of the Indian Constitution. Thank you, sir. I invite Dr. Uma Narayan, OST Registrar, to give a summarized idea of this web page.
Namaskar. Good afternoon to all the dignitaries on and off the dais and all those who are present. In celebration of the centenary marking Dr. B.R. Ambedkar's admission to the bar, the Supreme Court Judges Library has developed a web page featuring numerous links. The Bombay High Court has kindly shared the digital reproduction of some original documents and judgments. The home page serves as a comprehensive introduction to the life of Dr. B.R. Ambedkar, featuring a digital representation of his portrait located in the Central Court of the Bombay High Court. The certificate page has a digital reproduction of Dr. B.R. Ambedkar's barrister certificate from Grace in London, dated 28th June 1922. The original certificate is housed in the Bombay High Court. The application page includes a concise account of Dr. B.R. Ambedkar's law practice, accompanied by the digital copy of his application to the Bombay High Court dated 25th June 1923, seeking admission as an advocate. The rear side of the application reveals that Justice Kajiji granted him advocate status on 5th July 1923. The case law page itemizes 29 cases in which Dr. Ambedkar served as an advocate. 28 in Bombay High Court, 1 in the Supreme Court, referenced from the compilation, court cases argued by Dr. Baba Saheb Ambedkar in 3 volumes by Mr. Vijay B. Gaikwad. The links to the complete text of the judgments are sourced from the All India Reporter. Some cases offer links to the original judgments of the Bombay High Court. Should I open the judgments? No, one show. This is the scanned record from the Bombay High Court. Should I show the entire judgment? No.
Go a little slow.
Okay, sorry.
So this is a... This is the paper book of the case now.
Workman's compensation.
Should we go ahead?
वो पीछे वाला जो है ना, वो 28 वाला original था judgment.
Uma, you can go ahead, I think.
Yes, my lord.
It's a paper book followed by the judgment.
Some are original judgments are there.
Yes.
This one is a paper.
You can,
The next page is we have shown the Mahat Satyagraha led by Mahat Satyagraha was led by Dr. Ambedkar for right to water in 1927. The issue was only certain people were allowed to use the water from the Chowdhury tank situated in Mahad, and others were refrained to use the same. Dr. Ambedkar and his supporters led a non-violent protest for equal access of water by all. A lawsuit was filed on 12th December 1927, and Dr. Ambedkar was one of the defendants. The title of the case was Narhari Damodar Vaidya versus Dr. Bhimrao Ambedkar. In the lawsuit, the defendants, including Dr. Ambedkar, argued that the Chowdhury tank belonged to Mahad municipality and should be open to all. The trial court ruled against the plaintiffs, stating that they failed to prove a long-standing custom excluding certain group of people from using the tank, and that this custom did not qualify as a legal right. This suit was decided on 8th January 1931. An appeal was filed against the decision in the Thana court. The assistant judge Thana affirmed the lower court's ruling on 30th January 1933. Subsequently, the plaintiffs appealed to the Bombay High Court. The High Court also dismissed the appeal on 17th March 1937. After almost 10 years of struggle, Dr. Ambedkar was able to secure legal victory for his people. The digital versions of the judgments of the Mahad Court, Thana Court, and original judgment of the Bombay High Court are given in this page. There is a typewritten original judgment. Sorry. Quorum was Justice Broomfield and Justice Wadia. Here the links to the text and the video recording of significant speeches delivered by Dr. Ambedkar in the Constituent Assembly is given. These are the PDF documents, and this is one of the YouTube links of 17 December 1946.
So far, as the ultimate goal is concerned, I think none of us need have any apprehension. None of us need have any doubt. But my fear, which I must express clearly, is this. Our difficulty, as I said, is not about the ultimate future. Our difficulty position of mere legality. It is not a legal question. I say leave aside all these considerations and make some attempt whereby those who are not prepared to come will come. Let us make it possible for them to come. Thank you, sir.
Beautiful speech. Very good. So, जैसे जब मुस्लिम लीग अभी से कल आपको बताया था, मुस्लिम लीग doesn't want to join.
The subsequent page showcases the books and publication authored by and about Dr. Ambedkar, available in the Judges Library, Supreme Court. Additionally, two links are given to the websites where the digital version of his writings and speeches are provided. Finally, there is a photo gallery displaying important images sourced from the website drambedkar.co.in. We are confident that this web page will be beneficial for all those interested in gaining insights into Dr. Ambedkar's legal journey. Thank you.
Thank you, ma'am, for a touching showcase. It was wonderful indeed. May I now request Honorable Chief Justice of India to present a memento to Honorable Minister of State, Law and Justice. May I request Honorable Chief Justice of India to also present a copy of Gender Handbook, Supreme Court Chronicle, a newsletter from Supreme Court, and report on state of the judiciary to the Honorable Minister. Thank you, sir. May I request Honorable Minister of State, Law and Justice, Shri Arjun Ram Meghwal, to address the audience.
Honorable Chief Justice of India, Dr. न्यायमूर्ति D.Y. चंद्रचूड़ साहब और श्री न्यायमूर्ति B.R. गवई साहब, जज ऑनरेबल सुप्रीम कोर्ट ऑफ इंडिया, विशिष्ट सभी अतिथिगण, देवियों और सज्जनों, पहले तो मैं CJI साहब को धन्यवाद देना चाहता हूं कि मैंने बातों बातों में कोई विषय रखा और इस विषय को इन्होंने आज यहाँ पहुँचा दिया और आज सुप्रीम कोर्ट में अपने एक टेक्निकल सेशन में इसी विषय पे चर्चा कर रहे हैं। CJI साहब, आपका बहुत बहुत बधाई और बहुत बहुत धन्यवाद। बहुत ही सुंदर कार्यक्रम आपने हाथ में लिया। दो और धन्यवाद देना चाहता हूँ। मुझे पता नहीं कि किस तरह की इन्होंने मेहनत की होगी रात और दिन, क्योंकि हम 3-4 महीनों से इसको डिस्कस कर रहे थे। एक है डॉक्टर उमा नारायण, अभी अभी बोल रहे थे आप, इनके लिए भी जोरदार तालियां बजनी चाहिए। और एक है अनुराग भास्कर, वो इधर खड़ा है कि नहीं खड़ा? हाँ, इधर खड़ा है। इनके दोनों के लिए थोड़ा जोरदार ताली बजाओ, बड़ी मेहनत की इन्होंने। वाकई काफ़ी मैं चर्चा में था। अभी आवाज़ सुनी हमने बाबा साहब भीमराव अम्बेडकर जी की। सब्जेक्ट आपके सामने हैं। मैं 2-3 चीज़ें आपको कहूँगा। आवाज़ भी बहुत शानदार है। ये विषय है 9 दिसंबर 1946 को हमारी संविधान सभा बैठी, तो उसमें 299 जो मेंबर थे हमारी संविधान सभा के, वो सब सम्मिलित हुए। लेकिन उसमें सम्मिलित होने थे उसमें, लेकिन उसमें राजाओं के प्रतिनिधि नहीं आए और मुस्लिम लीग ने बाइकाट किया। तो उस समय एक हमारे संविधान का उद्देश्य क्या होगा, उसके लिए प्रस्ताव रखा पंडित नेहरू जी ने। तो कुछ लोगों ने कहा अभी चर्चा करो, कुछ लोगों ने कहा अभी चर्चा मत करो। लेकिन बाबा साहब डॉक्टर अंबेडकर का जो एक लीगल बैकग्राउंड था, उसके आधार पर वो लॉजिकल बात करते थे, और लॉजिक सबको बाद में उस समय समझ में आया। जो भी आप भाषण जो सुना रहे थे, ये 17 दिसंबर 1946 का है। पहले पे विवाद हो गया, किसी ने कहा कौन बोलेगा कौन नहीं बोलेगा। फिर चर्चा हुई कि जो M.R. जैकर ने एक प्रस्ताव रखा कि जब तक मुस्लिम लीग नहीं आई, वो पूना से आते थे, जहाँ से हमारे ऑनरेबल चीफ जस्टिस ऑफ इंडिया महाराष्ट्र से आते हैं, वहीं से महाराष्ट्र के ही M.R. जैकर थे, अच्छे वकील थे। उन्होंने कहा कि आप जो ये बात है कि मुस्लिम लीग जब तक नहीं आए और राजाओं के रिप्रेजेंटेटिव भी आने थे, तब तक आप नई चर्चा करो तो ठीक है, वो समर्थन किया। लेकिन नेहरू जी का प्रस्ताव था कि अभी चर्चा करो। अब देखिए, उस समय नेहरू जी के मानने वाले बहुत लोग, कॉन्स्टिट्यूंट असेंबली में भी बहुत लोग, उस पीरियड में सबसे पहले सच्चिदानंद जी थे हमारे कॉन्स्टिट्यूशन संविधान सभा के अध्यक्ष, लेकिन उसके बाद डॉक्टर राजेंद्र प्रसाद चुन लिए गए थे। तो राजेंद्र प्रसाद जी ने सोचा कि डॉक्टर अंबेडकर बहुत लॉजिकल बोलते हैं, इनको शुरू करें क्या। कोई चर्चा करना तैयार नहीं था। तो 17 दिसंबर को जब बाबा साहब डॉक्टर भीमराव अंबेडकर खड़े हुए, तो जो उनका भाषण है, उस भाषण ने उनको अमर कर दिया। उस भाषण ने ही अमर कर दिया। आदिश अग्रवाल जी जोर से ताली बजा रहे हैं, जोर से बजाओ, फिर तो बजा रहे हो तो। हाँ। क्या कहा उन्होंने कि कितनी छावनी बनाओगे भाई, हम संविधान सभा में बैठे हैं, हॉल एक है, लेकिन इसमें भी छावनियां हैं। कोई कहता मैं मराठा हूं, कोई कहता मैं पंजाबी हूं, कोई कहता मैं मद्रासी हूं, कोई कहता मैं ये हूं, कोई कहता मैं ये हूं। हम जातियों में भी बंटे हैं, धर्मों में भी बंटे हैं, क्षेत्र में भी बंटे हैं। ये देश को ऐसे एक कैसे करेंगे अपन। जैसे ही बोलने खड़े हुए लोगों ने कहा ये तो कुछ और बोलने वाला था, इसका चरित्र तो ऐसा होना चाहिए, इसका चरित्र ऐसा होना चाहिए, आज हम इसकी हुटिंग करेंगे, इसको बोलने नहीं देंगे। लेकिन जैसे ही पहले ये शब्द यूज किया कि हम देश में भी छावनियों में बैठे हुए हैं, या हम संविधान सभा में भी छावनियों में बैठेंगे क्या हमें देश को एक नहीं रखना। अगर आपको देश को एक रखना है तो मेरा मानना है कि M.R. जैकर ने कोई गलत बात नहीं की है, आप उसको बोलने नहीं दे रहे हो। M.R. जैकर भी बड़ा आदमी है। तो जैसे ही अंबेडकर बोलते गए 1 घंटा से ज्यादा का भाषण है, कितनी बार ही तालियां बजी। सरदार पटेल पहली बार प्रभावित हुए कि यार ऐसे बोलते हैं क्या डॉक्टर अंबेडकर। ये वकील के कारण बोल रहे हैं। 2-3 घटनाएं वकील की मैं बताऊंगा। उसके बाद जो 17 दिसंबर का जो भाषण था, उसके बाद ये आपका जो बांग्लादेश जहां से सुन के आए थे, वो एरिया, वो एक रेड कौन सा आया था, एक अंग्रेज आया था ना, आदिश अग्रवाल जी, रेड क्लिफ नहीं, हाँ रेड क्लिफ, वो आया था। तो उसने वहां कराची में बैठ करके पता नहीं देश का नक्शा खींचा कि 50% से ज्यादा आबादी कहीं होगी मुसलमानों की, वो एरिया पाकिस्तान में जाएगा, बाकी हिंदुस्तान में रहेगा। तो जहां से बाबा साहब चुन के आए थे, वो आबादी तो 48% थी मुस्लिम समाज की। अभी जो बांग्लादेश है, बंगाल से आए थे, लेकिन वो एरिया चला गया पाकिस्तान, पूरी पाकिस्तान, अब बांग्लादेश है। तो ये तो बिना मेंबर के ही रह गए। डॉक्टर अंबेडकर संविधान सभा में नहीं आए। उन्होंने कहा इनका एरिया तो गया ये पाकिस्तान में। अब ये पाकिस्तान, उन्होंने कहा मैं पाकिस्तान नहीं जाता, मैं हिंदुस्तान में रहूंगा। जोगेंद्र मंडल ने कहा पाकिस्तान आ जाओ। उन्होंने कहा मैं पाकिस्तान नहीं जाता, मैं हिंदुस्तान में रहूंगा, हिंदुस्तान को एक रखूंगा, हिंदुस्तान को महान बनाऊंगा, हिंदुस्तान की संस्कृति को प्रमोट करूंगा। तब उन्होंने कहा यार ये तो ऐसे आदमी हैं। तब फिर M.R. जैकर, कितना बड़ा त्याग था उस समय M.R. जैकर साहब का, लोग भूल गए, किताबों में लिखा नहीं ढंग से। M.R. जैकर साहब ने इस्तीफा दिया आपके स्टेट से, मराठा से। उन्होंने सीट खाली की। उस सीट पे भी कई लोग की नजरें रहती है, जैसे अब आपके यहाँ कोई सीट खाली हो जाती है, हमारे यहाँ की सीट खाली, नजरें तो रहती है। तो उस सीट में भी कई नजरें रही। सुनीता जी आप भी जोर से हंस रहे हो ना, बहुत। सुनीता जी के लिए ताली बजाओ भाई, इतना आनंद आ नहीं, मैं इसलिए बजा रहा हूँ, ये हैप्पीनेस है जी, हम हंसते ही नहीं है जी, इसके लिए तो कोई बजट लगता ही नहीं है ना, इसमें क्या दिक्कत है। तो उसके बाद उन्होंने कहा क्या करना चाहिए, तो एक खरे कोई आपके चीफ मिनिस्टर थे बॉम्बे, क्यों कवि साहब आपको आइडिया होगा ना, खरे खेर वीजी खेर, उनको चिट्ठी लिखी, वो मैंने अभी नेहरू लाइब्रेरी से निकाल ली, उनको चिट्ठी लिखी सरदार पटेल साहब ने कि 17 दिसंबर के भाषण के बाद मेरा थॉट डॉक्टर बी.आर. अम्बेडकर के प्रति बदला है, अगर कोई और टिकट मांग रहा है वहां से तो किसी को मत आने देना, तुम डॉक्टर अम्बेडकर को ही चुन करके भेजना। इसलिए डॉक्टर अम्बेडकर संविधान सभा में आए। उसके बाद तो आपको पूरी हिस्ट्री पता है, ड्राफ्टिंग कमेटी के सदस्य बने, उसके बाद चेयरमैन बने, अब ये वकील 1923 में बने। वकील की जो भूमिका होती है वो हर जगह रही उनकी। अभी कुछ जो डॉक्टर उमा नारायण ने जो चीजें हमें दी, ये एक इनिशियली स्टेज के एडवोकेट के रूप में चीजें थी। एक घटना, कितना सीजे साहब मेरे पास टाइम कितना है, एक तो ज्यादा टेक्निकल सेशन ही है, 5-7 मिनट है अभी, और क्या 5 मिनट है। एक घटना मैं बताता हूं, चलो उस घटना को फिर छोड़ता हूं, मैं स्किप करता हूं क्योंकि जिस दिन से इंडिकेशन है। लेकिन एक और अच्छी घटना है जो मैं आपको बताता हूं। वकील के रूप में वो बहुत फेमस हो गए कि ये गरीब जो लोग होते हैं, जो लेबर क्लास है, उनके केस ये फ्री में लड़ते हैं। ऐसे बहुत बड़ा नाम था डॉक्टर बी.आर. अम्बेडकर साहब का, और ऐसा एक केस फ्री में लड़ा एक सुरई का, हमारे महाराजा का, उसका कभी जिक्र करूंगा। लेकिन एक लॉजिकल एंड पे जो एक चीज को लेके गई वो मैं आपको बताना चाहता हूं। कई बार अपने को पता रहता है भी, पता चलता है ऐसे कैसे हो गया। एक समिति थी साहब संविधान सभा में, जिस समिति का नाम था राष्ट्र ध्वज समिति थी। वो राष्ट्र का ध्वज कैसा हो, उसको लेकर के एक समिति थी। उस समिति में जब बहस हुई, ये सदस्य तो काफी थे, लेकिन जब बहस हुई समिति में, अब ये पन्ना कहीं इधर उधर हो गया लेकिन मैं बताता हूं। चरखा, जी 3 रंगों का अपना ध्वज है ना, इसमें ये मेंबर थे डॉक्टर अम्बेडकर। तो किसी ने कहा कि जो पुराना जो चरखे वाला है यही रख दो झंडा। बोलते गए, डॉक्टर अम्बेडकर ने भी कहा चरखा के अलावा और कुछ हो सकता है, तो 3 रंग का अपन झंडा मानते हैं, हमारा झंडा जो है तिरंगा है। लेकिन उसमें एक चौथा रंग भी है, मसीह साहब ठीक कह रहे हैं, एक चौथा रंग भी है, वो ब्लू कलर का अशोक स्तंभ है ना। तो धम्म का एक प्रतीक उनको लेना था, तो चरखे पे डिमांड चल रही थी। किसी की आई बात के स्वस्तिक कर दो, हमारा ये भारतीय संस्कृति के हिसाब से स्वस्तिक अच्छा, बीच में स्वस्तिक डाल दो। अब यहां जब चरखा आया तब चरखे पे डिमांड चलती गई कि चरखा ठीक है, 24/7 चलने की बात भी करता है, चरखा ठीक है। और चरखा कई कांग्रेसी चाहते थे और कहते थे महात्मा गांधी का थॉट भी उसमें आ जाएगा। लेकिन डॉक्टर अम्बेडकर खड़े हुए, उन्होंने कहा जी चरखे के अलावा मैं एक सुझाव देता हूं आपको। उन्होंने कहा वो क्या सुझाव है? उन्होंने कहा कि हमारे एक दिन में 24 घंटे होते हैं, ये जो आपका धम्म का चक्र है सम्राट अशोक का, इसमें 24 चक्र है, 24 वो दालियां, और 24 ही घंटे होते हैं। और हर जो दालियां क्या बोला उन्होंने, डंडिया, उस पे एक गुण है। जैसे एक गुण है प्रेम, एक गुण है दया, एक गुण है करुणा, ऐसे 24 गुणों का जिक्र किया और नेहरू जी को समझाया, सरदार पटेल को भी समझाया कि ये जो झंडा है ये खाली झंडा नहीं होता है, ये देश का एक प्रतीक होता है। जैसे हमारी करेंसी हमारा प्रतीक है, हमारा झंडा हमारा प्रतीक होगा, हमारा संविधान हमारा प्रतीक होगा, हमारी सेना हमारी प्रतीक होगी, संप्रभुता को रिफ्लेक्ट करेगा ये झंडा। इसलिए झंडे में ऐसा एक चिन्ह दो जो हमारी संस्कृति से भी जुड़ा हुआ हो और लोग उसको लाइक करें, तो उन्होंने कहा क्या है ऐसा, तो उन्होंने जैसे ही अशोक चक्र का जिक्र किया, धम्म चक्र का जिक्र किया और उसको महात्मा बुद्ध से जोड़ा और कहा कि इसमें 24 गुण है। जो मनुष्य झंडे को देखेगा तो उन 24 गुणों को स्वीकार करेगा। मुझे दया आनी चाहिए, मुझे करुणा आनी चाहिए, मुझे प्रेम, मेरे में प्रेम रहना चाहिए, मैं लड़ाई नहीं करूं ऐसा मेरे में गुण आना चाहिए। 24 गुणों को वो इंडिकेट करेगा और ये 24x7 को भी इंडिकेट करेगा। घंटे भी 24 हैं और इसमें तिल्लियां भी 24 हैं। और आप मेहनती नागरिक बनाने के लिए आप इसमें चरखे की बजाय ये अशोक स्तंभ डाल दो। और सारे सदस्यों को एग्री कराया। फिर किसी ने पूछा कि यार ये हो तो चरखा रहा था डॉक्टर अंबेडकर, आपने इसको ऐसे कैसे डलवा दिया? तो उन्होंने कहा मैं एडवोकेट हूं, मुझे पैरवी करनी आती है, मैं एडवोकेट हूं बेसिकली, मुझे पैरवी करनी आती है। और जब मैं खड़ा हुआ यहां तो मैंने देखा यहां मेरा जो लीगल बैकग्राउंड है वो काम आएगा कि नहीं आएगा। ऐसी जोरदार पैरवी की कि वो झंडे में अशोक जो धम्म चक्र है वो आ गया और अपना झंडा वैसे तिरंगा है लेकिन रंग 4 है साहब उसमें, ये नीले रंग का अशोक चक्र भी है, लेकिन इसको हम ग्रहण नहीं करते। इसमें 24 गुण है। मैं अभी उमा नारायण जी आपको देके जाऊंगा, वो मुझे यहां पन्ना नहीं मिल रहा है। 24 गुण उसमें कौन कौन से हैं? प्रेम, करुणा, दया, कर्तव्य निष्ठ, जो हमारे इसमें डायरेक्टिव प्रिंसिपल स्टेट में है, इसी तरह के गुण है वो 24। तो हमें 24x7 काम करना चाहिए और देश का हम श्रेष्ठ नागरिक बने। झंडे को देकर के भी हमें गुण आना चाहिए। कोई हमें गुरु ज्ञान देकर के हमारे में गुण प्रवेश करवा सकता है, लेकिन क्या झंडा भी हमारे में गुण प्रवेश करवा सकता है क्या? ये भाव अगर किसी ने रखा संविधान सभा में तो डॉक्टर B.R. अम्बेडकर बाबा साहब ने रखा। इसलिए हम एज एन एडवोकेट जो उनके काम है उनका जिक्र कर रहे हैं और ये संविधान में रिफ्लेक्शन हुआ। अब एक चीज मुझे याद आई गई, इसलिए 2 मिनट और लूंगा। एक विषय आया मताधिकार का, तो विषय चला कि इस देश में तो अनपढ़ लोग हैं, इस देश में गरीब लोग हैं, वो वोट का मतलब ही नहीं जानते। ऐसा करो जैसे कोई नगर सेठ है हमारे देश में, वो 1 वोट देवे और 20,000 गिन लो। कोई राजा है वो 1 वोट देवे और 50,000 गिन लो। कोई बड़ा राजा है तो 1 वोट देवे 1 लाख गिन लो। ऐसे करके 22 करोड़ के करीब मतदाता थे उस समय। तो 22 करोड़ पूरे हो जाएंगे, सबको वोट मत दिलाओ और महिलाओं को तो दो ही मत। और उस समय तो अमेरिका को भी महिलाओं को लेट मिला मताधिकार, इंग्लैंड में भी लेट, अमेरिका में भी लेट, तो यहां जल्दी क्यों देते हो? तो उस समय डॉक्टर अंबेडकर खड़े होते हैं, या फिर एडवोकेट का काम करते हैं डॉक्टर अंबेडकर, पैरवी करते हैं। जो बोल नहीं पा रहे थे वो संविधान सभा में नहीं आ पा रहे थे, अनपढ़ लोग, गरीब लोग, वंचित लोग, महिला, खाली 15 महिलाएं थी, उन्होंने भी स्वीकार कर लिया कि ठीक है बाद में दे देना। लेकिन डॉक्टर अंबेडकर खड़े हुए, खड़े होकर के उन्होंने नेहरू जी की तरफ देखा और नेहरू जी को कहा कि पंडित नेहरू थोड़ा मेरी तरफ देखिए। उन्होंने कहा क्या? कि ऐसा मत करिए, पाप हो जाएगा। अडल्ट फ्रेंचाइज, मताधिकार सबके लिए एक साथ करिए। बोला क्यों? कि अभी आप कह रहे थे मुझे 2 घंटे पहले कि मैं एशियन और अफ्रीकन देशों का लीडर बनना चाहता हूं और इंडिया लीडर बन सकता है। तो हमारे बाद जो देश आजाद होंगे अफ्रीका और एशिया के, कुछ नया हम नहीं देंगे तो हमसे क्यों वो ग्रहण करेंगे? आप अगर नया देना चाहते हो तो मैं कहता हूं एक साथ मताधिकार दे दीजिए, गरीब को भी, अमीर को भी, महिला को भी, पुरुष को भी, पढ़े लिखे को भी और अनपढ़ को भी। आप मताधिकार एक साथ करके देखिए, आप बहुत बड़े लीडर बन जाओगे और एशिया और अफ्रीका में पूजे जाओगे। तो नेहरू जी भी समझ में आ गया, यार बात तो ठीक कह रहे। तो तर्क इतने मजबूत थे वकील के नाते कि नेहरू जी भी माने, संविधान सभा के दूसरे सदस्य भी माने और एक साथ मताधिकार मिला सबको, भारत में ही मिला। अदरवाइज तो हो सकता महिलाओं को मताधिकार कोई 10-20 साल बाद मिलता, 30 साल बाद मिलता। उन्होंने कहा एक साथ दो। उन्होंने कहा नहीं क्या करना है, पुरुष जो सोचेगा वही महिला सोचती है। बोला नहीं, महिला अलग से भी सोचती है, गरीब आदमी अलग भी सोचता है। और उन्होंने एक चीज और कही कि नेहरू जी जब ये लोग मताधिकार का प्रयोग करने जाएंगे तो जैसे ये होली और दिवाली मनाते हैं ऐसे ये सेलिब्रेट करेंगे। सब हंसे कि ये क्या कह रहे हो डॉक्टर अंबेडकर। आज मैं देखता हूं जब कभी चुनाव में जाता हूं, कोई ग्रामीण महिला आती है, सच धक कर आती, पूछता हूँ कहाँ जा रहे हो, वोट देने जाऊँ, तो वो जो वोट देने जा रहे हैं और सच धक के जा रहे हैं, सेलिब्रेशन के रूप में जा रहे हैं, जैसे होली और दिवाली मनाएंगे, जैसे डॉक्टर अम्बेडकर ने कहा था, ऐसे आज भारत में जो लोकतंत्र मजबूत हुआ है उसका बड़ा कारण मताधिकार है। मुझे आपने बोलने का अवसर दिया, उसके लिए आपको बहुत बहुत धन्यवाद। थैंक यू।
Thank you, Honorable Minister, for sharing interesting facts and enlightening us. May I now request Honorable Shri Justice B.R. Gawai to address the audience.
The Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, my esteemed colleagues on the bench in the Supreme Court of India, the Honorable Minister of State for Law and Justice, Shri Arjun Ram Meghwalji, the Honorable Chief Justices and Judges of the High Courts, Registrars and members of the audience. Today is a historic day. It is so because on this day in 1949, we as an independent nation adopted the Constitution of India. But today's date is historic for two more reasons. The first reason is that earlier today, the Honorable President of India unveiled the statue of Dr. B.R. Ambedkar in the premises of the Supreme Court of India. I have no manner of doubt that today's day will be written with golden words in the history of the Indian Supreme Court. I thank and congratulate the Honorable Chief Justice of India from the bottom of my heart for taking the decision to have a statue of Dr. Ambedkar in the Supreme Court. Dr. Ambedkar had famously called Article 32, which provides the right to Indian citizens to approach the Supreme Court, as heart and soul of the Constitution. The statue of Dr. Ambedkar is facing the court number 1, that is the Chief Justice's court. By placing the statue in front of the court number 1, we have paid homage to Dr. Ambedkar as well as reaffirmed his idea that the right to approach the Supreme Court is indeed the heart and soul of the Constitution. Today's day is also historic for a second reason. We are celebrating the centenary of Dr. Ambedkar's enrollment as an advocate. Dr. Ambedkar finished his study of law from Gray's Inn in London in 1922. After his arrival to India in 1923, he had applied for a license to practice law. Dr. Ambedkar had enrolled as an advocate and started practicing before the Bombay High Court in July 1923. The fruits of constitutionalism which we cherish today were sown by Dr. Ambedkar a century ago. I had the fortune of inaugurating a court at Mandangarh in which Dr. Ambedkar's native village, Ambode, which is situated along with the Honorable Chief Justice of Bombay High Court, Justice Devendra Upadhyay. Born into a society marked by deep-rooted social hierarchies and discrimination, Dr. Ambedkar faced adversity with unparalleled challenge and courage. Dr. Ambedkar's writings since 1919 focus on the recognition of equal rights for all the citizens. He emphasized on interconnection between rights, citizenship, and constitutionalism. He theorized citizenship as a bundle of rights, which include fundamental rights and the right to participate in a democracy. Dr. Ambedkar aimed at shaping the discourse of the society through constitutionalism. He attempted to address the social problems through the framework of law and the Constitution. It is for this reason that he emphasized on having detailed provisions in the Constitution so that there is no scope of arbitrariness in the actions of the decision makers as well as the society. Dr. Ambedkar's constitutional ideas were not limited to lawmakers and judges. He envisaged a public discourse on the values of the Constitution. He had once pointed out that fundamental rights provided by the Constitution ought to be protected by the social conscience of the citizens. That is, the citizens need to respect the fundamental rights of their fellow citizens. Dr. Ambedkar was also a strong proponent of constitutional traditions and practices. He believed that constitutional practices which may not be entrenched in the text of the Constitution are conditions precedent for the successful working of a democracy. He therefore hoped that citizens and constitutional authorities would respect the constitutional traditions. Today, the Supreme Court has also launched a web page on the centenary of Dr. Ambedkar's enrollment as advocate. The web page contains a list of cases argued by Dr. Ambedkar. This web page will act as a source of great knowledge for the common citizens and a valuable resource for scholars and researchers. The most celebrated case in which Dr. Ambedkar participated is the case to enter the Chaudhar tank in Mahad in Maharashtra. In 1923, S.K. Bole, a social reformer, moved a resolution in the Bombay Legislative Council which provided that untouchable classes be allowed to use all public watering places which are built and maintained out of public funds. Thereafter, the Mahad municipality passed a resolution to open the Chaudhar tank for depressed classes. However, the municipality's resolution could not be implemented due to opposition from the oppressor caste of that area. In March 1927, Dr. Ambedkar led a group of individuals belonging to the oppressed caste and drank water from the tank to assert their right of equal access to public resources. This movement is celebrated as the Mahad Satyagraha. However, due to retaliation and pressures from the oppressor caste, the Mahad municipality in August 1927 revoked its resolution to allow the untouchable community to access the tank. Thereafter, Dr. Ambedkar again called for a conference in Mahad in December 1927. However, before the conference could take place, the caste Hindus filed a civil suit for injunction against Dr. Ambedkar and his associates to restrain them from entering the tank. The plaintiff claimed that the tank was a private property. A temporary injunction was granted by the court. Dr. Ambedkar then decided to take up the legal battle, which went on for almost a decade. I am glad that the Supreme Court Judges Library has acquired the original case records pertaining to Mahad Satyagraha and has uploaded it on the web page. In the Mahad case, Dr. Ambedkar, strategically planning his defense, successfully argued that the tank was a public asset and should be accessible to all the segments of the society equally. In its ruling, the Mahad Court ruled that the plaintiffs could not establish ownership of the tank. Both the appellate courts, including the Bombay High Courts, ruled in favor of Dr. Ambedkar. Among other notable cases, Dr. Ambedkar in 1934 successfully defended the All India Textile Workers Conference by exposing the shortcomings in the Trade Disputes Act of 1921. He also provided a legal defense for Dr. R.D. Karve, who faced charges of obscenity for his work, Samaj Swasthya, a publication on sexual hygiene. Dr. Ambedkar had several quibbles with the social inequalities prevalent in 19th century India, the evils of which he had suffered greatly. This, however, never made a dent in his zest for patriotism and nationalism. He was a patriotic to the core. It will be apt to quote from his speech made on 17 December 1946 at the Constituent Assembly. And I quote, "While deciding the destinies of nation, dignities of people, dignities of leaders, and dignities of parties ought to count for nothing. The destiny of the country ought to count for everything." Unquote. Furthermore, Dr. Ambedkar was of the firm belief that a constitutional democracy formed on the bedrock of inequality would never truly prosper. In his Ionic speech that could not be delivered but was later published, The Annihilation of Caste, he mentioned that an ideal nation can only be built with the ideas of liberty, equality, and fraternity. It is his brainchild that India embraced the trinity of liberty, equality, fraternity into the text of the Constitution. On 25th of November 1949, on presenting the Constitution, he warned that there were a lot of contradictions present in political and social life, and if left unchecked, they would put the foundational democracy of India in peril. In his words, and I quote, "On the 26th January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? How long shall we continue to deny equality in our social and economic life. If we continue to deny it for long, we'll do so only by putting our political democracy in peril. We must remove these contradictions at the earliest possible moment, or else those who suffer from inequality will blow up the structure of the political democracy which this assembly has laboriously built up. Dr. Ambedkar believed that we not only need a system of political democracy, but also a social democracy. He said, and I quote, "Political democracy cannot last unless there lies at its base the social democracy." Today, it is essential to recognize that Dr. Ambedkar's mission is far from complete. His ideals remain a beacon, guiding us through contemporary challenges and inspiring us to confront issues of inequalities that still persist in various forms. On this day, the best way to pay tribute to him would be to take a pledge that we leave no stone unturned in giving effect to the dream of Dr. Ambedkar and the other framers of the Constitution of India for ensuring that the country achieves social and economic equality along with political equality. Thank you very much.
Thank you, sir, for throwing light on Baba Sahib's life and inspiring us. We would like to acknowledge the dedication and artistic skills of Shri Naresh Kumar Kumawat in crafting the sculpture of Dr. B.R. Ambedkar in record time, which has been unveiled by the Honorable President of India today in the premises of the Supreme Court. We also acknowledge the tireless efforts of Shri Purnesh Kumar, Project Director, Supreme Court Project and Maintenance Circle, CPWD, for timely completion of installation of this sculpture. I request Honorable Chief Justice of India to give the certificate of appreciation to Shri Naveen Kumar Kumawat and Shri Purnesh Kumar for their commendable work. Thank you, sir. May I now request the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, to address the audience.
My very distinguished colleague, Justice Bhushan Gavai, who since my days is a judge of the Bombay High Court, I fondly referred to as HMJ. I was Mr. Arjun Ram Meghwalji, Union Minister of State for Law and Justice. But let me first begin on a lighter note. I was telling Meghwalji about why I call Justice Gavai HMJ. And the reason is that in the Bombay High Court, whenever you attend a public function, the names of the judges, instead of putting for everybody Honorable Ms. Justice, Honorable Mr. Justice, or everything in Mumbai is in short forms, right? Mahatma Gandhi Road becomes MG Road, so everything becomes in short form because the city is always on the move. So they write HMJ. So when he became a judge, we decided to call him HMJ. So he has continued to be HMJ since the first day that he became a judge and right now. I had a prepared speech really, but I thought, we're in a post-lunch session and we have heard two excellent speeches from Mr. Meghwalji first and then thereafter from Justice Gavai. But thank you all of you for joining in. All my distinguished colleagues are here from the Supreme Court. I know it's really a day of rest otherwise for them that they've all come here, and I sincerely thank all of my colleagues who are here in the audience. Chief Justices of the High Courts who are here, judges of the computer committees. This session is in itself very important, but I think this session is not just about the fact that we have set up the statue, but there is something far more profound in the reason why we have set up this statue and what is going to follow now. In a way, Dr. Ambedkar really belongs to all of us. I think gone are the days when we can say that people called him the leader of the untouchables. He is not a leader of the untouchables. He represents really the entire nation. He represents the voice of the nation. And the more one reflects on the life and times and teachings of Dr. Ambedkar, one realizes that his effort was not just to bring about a measure of social reform or to mobilize his own people for whom he led the cause of social justice, but this was essentially an effort to reform Indian society itself. That's why I always believe that while on the one hand, India is, ever since the time of just Dr. Ambedkar, facing these and witnessing these large social reform movements of mobilization. And we as judges see how our court is being used for engaging in a public discourse on various aspects of marginalization. Yet I always do believe that bringing social justice to the marginalized is not a project to the marginalized alone. Just as I always believe that bringing gender justice is not a project for women or those who are. What he regarded was years and years of discrimination. So in that sense, the statue which the Supreme Court has set up today, it represents the abiding quest for equality in our society. Because the most fundamental of values in the Constitution are represented by equality and fraternity. Liberty without equality and fraternity would really be only a hoax. Therefore, it is when you have conditions of equality, when you have a condition of fraternity, that you can truly aspire for true liberty. The setting up of this statue, this afternoon session, originated in a number of conversations which I must acknowledge. I think I've unfairly received too much of the share of the credit since the morning for what has happened this morning. When Mr. Arjun Ram Meghwal became Union Minister, and we have wonderful conversations with him on the state of the judiciary, appointments, transfers, budget, infrastructure, technology, we normally finish our work in about 20 minutes to a half an hour. But thereafter, on a Sunday afternoon, the rest of the 1.5 hours is talking about just society, ideas, vision. And he really put this thought in my mind. He said that Dr. Ambedkar completes 100 years of his enrollment as a lawyer. So why doesn't the Supreme Court plan on doing something on the occasion? I must also acknowledge here the Union Minister was very gracious to ask both Uma and Anurag to stand up. A lot of these ideas have been shaped by my abiding conversations with Anurag. Anurag was my young intern when I was Chief Justice of the Allahabad High Court, and Justice Deven Upadhyay is here, Chief Justice of the Bombay High Court. And Deven brought Anurag one day to my chamber at Lucknow and said, I brought my young intern to come and meet you. So I had a conversation with him, and then he interned with me. When I came to the Supreme Court again, he came and interned with me. He thereafter clerked with me in the Supreme Court. Anurag himself belongs to the Bahujan Samaj. Anurag, one thing which I was always very struck by was his wide readership. The amount he read. He had a ton of books when his internship and law clerkship with me came to an end. About 4 or 5 young interns and lawyers in our office, the law clerks, all went with him carrying these tons of books with him. Anurag applied for a scholarship to the Harvard Law School. He was admitted to the LLM program of the Harvard Law School. He did brilliantly at the Harvard Law School and then came back and of course joined as a professor at the Jindal Global Law University. But he and I had a contract, and he said that, well, I'd come one day and come and work at the Supreme Court. And he's now part of our revamped Center for Research and Planning. A very fascinating person I met recently during my travel to the US was a young woman called Disha Wadekar. And Disha belongs to
one of those criminal tribes who were criminalized in India, the Parthi tribe. And we know, coming from Maharashtra, what tremendous prejudice that the tribe faces. And she has got admission for an LLM at the Columbia Law School. And I had this very long and sustained engagement with her, and both Anurag and Disha were together at this program which I was invited to deliver the annual Ambedkar Memorial Lecture at the Brandeis University. Brandeis, by the way, has a bust of Dr. Ambedkar. And Disha said something which really really struck me in my mind as we were in one of those sessions. And she says, were it not for affirmative action, I would not be here today where I am. Because that has given me a platform to compete on an equal footing. I would also really like to express my deep gratitude to both Justice Sanjeev Khanna and Justice Bhushan Gawai for the statue which has come up. I had just the idea, but honestly, a Chief Justice can implement only something that his colleagues are supportive of. So when I broached it with both Sanjeev and Bhushan in the morning, and I said, well, I've constituted this committee and I'd like you to both get started. The Union Ministry of Culture, which is of course also led by Meghwalji, they gave us all the assistance. We selected the best of these sculptors in the country. And the sculpture has been put up, the statue has been put up in record time. We also had construction workers in the Supreme Court who have worked day and night to install this. When I got videos of the statue being lifted on a crane and installed, I had the worst nightmares, but the crane was very strong, though the statue was also very heavy. It had to be a heavy statue of one of the most distinguished constitutional experts that India has known. My gratitude to the Center for Research and Planning, to Dr. Uma Narayan and to Sukhada Pritam and everyone there. But I'll be failing in my duty if I didn't tell you that the statue was actually put up last night or early this morning at 3 o'clock. The final finishing touches were completed only at 3 o'clock this morning, because we were battling because there were construction restraints in Delhi. So we had to be compliant with all of those activities. And I would like to particularly congratulate my entire team. The Secretary General Atul Kurekar is here. He was here till 3 o'clock last night. Mr. Mahesh Patankar should be here. I hope Mahesh is here. Mahesh Patankar, who worked ceaselessly and was sending me videos all through the night to tell me what is the stage of the installation. So really, this Mr. Rakesh Sharma, our registrar, who has been looking after this entire one-day event. So I thank all of you, my team, which has done what they have done. In the course of the speech by the President today, the President underlined very important aspects of our profession. And she said, what can we do to make our profession, and by that she meant both the legal profession and the judiciary, more diverse, more inclusive. The purpose of this session in the afternoon, this 1 hour session, is not to just celebrate the installation of the statue and then forget about it until the next case comes up when we refer to the Constituent Assembly debates. I believe this is the beginning of a series of dialogues. And I believe that we will have a series of engagements based on the life of Dr. Ambedkar right through the year now, as we enter into the 75th year of the founding of the Indian Supreme Court. And I thought I'll just highlight a few questions. The Chief Justices are here, senior judges of the High Court are here. First, based on what we have gained as an insight into the life of Dr. Ambedkar, what steps do we take to make our legal profession an inclusive profession? Can all of us say with our hand on our heart that we are an inclusive profession? Or is our profession essentially based on networks? How are young lawyers admitted into chambers? Is there a level playing field for people who come from marginalized backgrounds who are extraordinarily talented but just require a little bit of mentorship? Have we created a legal profession which is truly inclusive? Second, what are the significant obstacles which persons from marginalized backgrounds face when they enter the legal profession? Because these are duties which are cast on all of us, whether we are lawyers, as judges, to ensure that we confront these serious problems? Third, what steps should we adopt to provide diversity in the Indian judiciary? And fourth, what kind of mentorship has enabled those who have succeeded to succeed? We shouldn't just look at it from the negative perspective of what are the obstacles. Obviously, there are people who are succeeding and who have succeeded. Why have they succeeded? Who are the people who mentored them? What are the conditions in which they were able to overcome their conditions of discrimination or prejudice? So I do believe that what we will do now, after we conclude this particular session, is to have a series of engagements, not just on the Bahujan Samaj, but on the broader aspect of marginalization and its interface with the Indian judiciary. And how do we really ensure, what is it that we have to do? Somebody has to take those steps. I'm always asked, wherever I go now, and I've been engaging a lot in public consultations and public engagements, and I'm always asked, why are there not more women in the Indian judiciary? Why is it that you have only so many percent? And we'll see that in the next session as the figures come before you. Why is it that we have only so few women judges in the high courts? Why is it that we have so few women judges in the Supreme Court? There's something which I was in fact in conversation with the President last night. And I always explain to people that, well, in the Supreme Court, we draw upon a pool of available talent, where unlike, say, the American Supreme Court, where you can pick up almost anybody. You can make a senator a judge of the American Supreme Court. We can't make a senator merely because she's a senator a judge of the Supreme Court. You have to have a certain legal background. You have to have a certain degree of attainment in the legal profession. So we have to draw from the available pool. But how do we ensure that the available pool increases in the next 10 years or 15 years? Unless we take those steps now, as we will shortly see in the presentations, and I was actually here the whole day yesterday trying to look at the presentations, you will see that when it comes to the district judiciary, in several states in India, over 80% of the fresh recruits are women. 60% of the fresh recruits are women. 70% of the fresh recruits are women. That's an indicator to you of what is happening on the ground at the lowest levels. That is to say, if you give an even platform, of opportunity to people and treat them as individuals who will be able to succeed without all the trappings which our legal profession gives them or disadvantages them with, they're entitled to and will demonstrably succeed. Now, how do we create those conditions in the legal profession, the mainstream of the legal profession? Is there no obligation on lawyers? We have the lawyers here today with us. And the president of the chairperson of the Bar Council of India is here, President SCBA is here, Secretary of SCBA is here. So many lawyers are part of this session. In fact, the Dalit lawyers in the Supreme Court came to me the other day and said that putting up this statue is an act of enormous support for our community, because it highlights the fact that we are not really behind the scenes, but we are a vital force in the decision-making process of the Indian judiciary. These are some of the things which I thought I would highlight. In the US Supreme Court, I wanted to focus on one particular aspect. Just this summer, the American Supreme Court dealt with a case called Committee for Admissions to Harvard. And they sought to challenge the use of race as one of the criteria in affirmative action programs. The American Supreme Court, speaking through Chief Justice John Roberts, held that the color of your skin or your race should have nothing to do with your right to seek admission. And they've outlawed completely the use of race as even a factor in admissions. They never had quotas, but they would use race as one factor in admission decisions. Even that has been outlawed in the United States. Look how far and how progressive our law has been. We regard equality not merely as equality in a formal sense, but we regard equality in a more substantive sense. And therefore we believe, along really the legacy that Dr. Ambedkar has conferred upon us, that if you have to bring about true equality in society, you must factor in all those factors which lead to the loss of a level playing field. people from marginalized backgrounds do not have the kind of social capital. They do not have the kind of cultural capital. They do not have the kind of access to resources. Something as simple as access to coaching centers when you're appearing for the common law aptitude test. People from marginalized backgrounds are not as conversant with English, but our CLAT examination, which is a bedrock for entry into the legal profession, is entirely conducted in English. Now, by the very fact that the medium of the examination is in English, we are making our profession urban-centric, and it is wholly and completely biased against those who come from rural backgrounds, from marginalized backgrounds. What do we do as a profession to overcome this? I'll give you just one example of what the Supreme Court did recently. We have a clerkship program in the Supreme Court. It's an extremely vital tool for young members of the legal profession from all over the country for the purpose of their own advancement in life. What used to happen was that the clerkships typically, I know of a time in the Supreme Court when clerks were taken only from the National Law School. So if you didn't belong to a National Law School, you couldn't clerk with the judge of the Supreme Court, which I thought was extraordinarily discriminatory. In fact, part of our clerkship program was dealt with by Justice Rajiv Shakdar when he delivered judgment and said that what your people are doing is completely violative of Article 14. But we took the next step. Actually, I prepared a white paper last year, placed it before Chief Justice Ramana, and then eventually we have implemented it this year. And that committee also consisted of several of my very distinguished colleagues, headed by Justice Kaul. We have now completely reoriented our clerkship scheme so that clerks, we have an examination for recruiting of law clerks in the Supreme Court. This year we held the examination in over 20 centers all across India. After we held the examination was held in two parts. There were multiple choice questions as first part of the examination. Then we gave them brief judgments to prepare a research note, not more than a few hundred words. So it's something which they had to write in half an hour or 30 minutes. But the exam went on for the whole day. And the final aspect was a research note which you have to prepare for a judge. All this had to be done in the course of one day. We got some amazing people whom we have recruited. And we have allowed our judges then to interview those from the pool. We still give our judges a choice of selecting a few law clerks of their own, but the brunt of the law clerks come from this. The Supreme Court, in conjunction with the National Commission for Scheduled Tribes, has launched an internship program. The National Commission for Scheduled Tribes had approached me and said, why is it that our tribal students don't have access to the highest court? So we have engaged with the National Commission for Scheduled Tribes, and we are now engaging in a very modulated and a properly structured internship program. So I would really, the reason I thought I should talk more in practical terms as opposed to something very theoretically constructed around the life of this distinguished scholar, statesman, Constituent Assembly member, minister, and the architect of the Constitution and social reformer, is that I thought that we must all dwell today, since all the Chief Justices are here, senior judges of the High Courts are here, we must all reflect today on what we need to do to make the legal profession truly more inclusive. Just a couple of things on a little bit of a few pieces of anecdotal evidence about the life of Dr. Ambedkar. My father used to tell me that as a young lawyer, there was a cafe in Kalagoda in Mumbai called the Wayside Inn. The Wayside Inn later on became very well known among lawyers for a variety of other things. But in those days, Wayside Inn was where there was one gentleman who would sit there every afternoon, writing furiously. He would have sheets of white paper and he would be furiously penning something. Later on, people realized that this was nothing then, nobody else than the chairperson of the drafting committee, Dr. Ambedkar, who would sit in the Wayside Inn every afternoon, writing out what he believed was the structure of the Indian Constitution. The Justice Gavai spoke about the Mahar Satyagraha case. A very interesting case, actually, which I thought I must refer to all of you and then conclude what I have to say for the concluding part of this session. And that was a case which Dr. Ambedkar lost. not a case which Dr. Ambedkar won. Mahasatyagraha, he succeeded. But all of us know as lawyers that it is as much in the cases which you lose that you get the greatest satisfaction as opposed to the great cases which you have won. And this was the case where he defended Professor R.D. Karve's journal called Samaj Swasthya on charges of obscenity. And he was defending R.D. Karve. And Ambedkar mounted a spirited defense of the Gujarati journal which dealt with questions of sexual hygiene and family planning and proposed a legal test for obscenity which was way ahead of its times. Ambedkar lost the case, but eventually he successfully got the magistrate to admit that the taboo around sexual matters should end. So look at the vision, look at the depth of his understanding of society. Another case which he represented was involved the defense of Philip Spratt, a British communist who was arrested on charges of sedition. There's a very interesting article on Dr. Ambedkar's life by Rohit Day, a historian at Yale, in his paper called Lawyering as Politics, the Legal Practice of Dr. Ambedkar. And he says that Dr. Ambedkar's ability to be at equal ease defending the civil liberties of communists, Congress workers, landlords, indigents on death row, within the limits of colonial law required a particular kind of deafness, making him one of the earliest precursors to Indian civil rights lawyers. Ultimately, the alternating currents in my life. I do not know on which current my life will end, whether AC or DC. So as we celebrate 100 years of his enrollment as a lawyer, there can be no doubt that in each role that Dr. Ambedkar played, be it legal practice or public service, he has left strong currents that continue to power our polity. Thank you very much.
Thank you, Honorable Chief Justice. It's always a pleasure hearing you. You've been so very instrumental in sensitizing us towards significant aspects of inclusivity, gender, and diversity. Thank you, Chief. Well, as we come to end of this session, I thank everyone present here. We will be starting with session 2 in few minutes. Thank you so very much. We'll be starting with session 2